Yes, Mr. Hewitt, good morning.
Good morning, my lady, my lords. In this appeal, I appear for the revenue, the appellants and the respondents in the cross appeal, along with Miss Wilson, Miss Belgrano, Miss MacLeod, Mr. Wilmot Smith and Mr. Blades, and my learned friends Mr. Ailson and Mr. Bremner appear for the test claimants. So I shall refer to our side as the revenue or HMRC to avoid confusion with the appellants, and I shall refer to the other side as the test claimants if that's satisfactory. A little bit of housekeeping. Are the court working from hard copy bundles, could you indicate, or electronically, or both?
I'm working from hard copy.
Yes, me too. Both.
Both, okay. I'll bear that in mind. And there is a transcript being taken, as you
Thank goodness.
and you should have, hopefully, the suggested draft timetable.
Now that didn't reach me, Mr. Hewitt. I'm sure it's not anybody's fault, but are you able to give us a sort of rough outline of who's doing what and when?
I can. The agreement was that I would, first of all, I would deal with both the appeal and the cross appeal together,
sensible.
because they all come together. And I will take up to lunchtime tomorrow.
Right.
And then the other side will take over. And then I think the idea is that I will have an hour at the end to reply, and then they, if necessary, will have a further period because they have the opportunity to reply on their cross appeal right at the end. So we'll see how things go.
Well, that sounds sensible.
That's broadly the idea. The court will have seen that this litigation started in 2002.
Yeah.
I think maybe there are three survivors. Myself, Mr. Williamson, and maybe Mr. Farmer, I'm not sure whether he was there at the very beginning, but there are three survivors from the beginning. You'll have seen there have been two previous stages to the FII GLO where there was High Court proceedings before Mr. Justice Henderson and then an appeal to the Court of Appeal. And we refer to those as High Court 1 and High Court 2, and then there were Court of Appeal 1, Court of Appeal 2. And there have been 3 visits to the Supreme Court. Again, we refer to them 1, 2, 3. And of course, it's Supreme Court 2 that is particularly important in this appeal. And there have been 3 references to the European Court. The one which is particularly significant, again, for this appeal is the first reference, where the judgment was given in 2006. This case is of obvious importance. It's the first case following Supreme Court 2 in which, in the context of mistake of law, there has been a trial on the basis of Supreme Court 2. There is one other case that you may have seen referred to, Jastel, where on appeal after the trial, Supreme Court 2 was decided and was applied, and I'll come to that. But this is the first case which has actually been applied at the trial on the evidence. Just to indicate perhaps the wider importance, you will be aware, I'm going to come to this in a moment, there is another parallel group litigation which is referred to as the CFC and dividend GLO. The dividend part of that is the part that has been going in parallel with the FII proceedings. The decision in this appeal will have consequences for that GLO. There is a wrinkle to this because there is a case going through the courts. It's been decided by this court and it's now going to appeal to the Supreme Court, called AXA, which is considering whether, in fact, the followers in the CFC and dividend GLO can apply the old law under DMG rather than the new law under Supreme Court 2. Now, so far the Court of Appeal has said it's a new law, but there is an appeal on that, as I say, to the Supreme Court. There is also, I'm told, I'm not involved in this, a stamp taxes GLO, where this might be relevant, and I think Jastel was part of that. And of course it is important for the law generally, because mistakes of law can occur outside the context of European law and tax. Can I then also, before I delve into the submissions, just make clear for the court, because I don't know that any member of this court has had the misfortune to be involved in any of this litigation previously.
I was involved in AXA, but it's a slightly different point.
Yes. Could I just make clear what the different types of claims are that you'll see referred to, because they are subtly different. Now the FII claims, which are the ones that we are dealing with, they are dealing with situations where UK companies receive dividends from subsidiaries in other member states. So if you imagine a simple diagram with a UK company and below it an EU subsidiary, and above the UK company there are the shareholders. So what happens is dividends are paid by the EU company to the UK company. In the time that we are dealing with, they were taxed, subject to corporation tax at the full rate. However, they were able to obtain double tax relief for the tax which was actually paid by the subsidiary on its profits in the foreign state. That was under double tax treaties generally.
And that was not the position in relation to a UK subsidiary paying dividends in similar circumstances, because that wasn't taxable at all, was that?
Exactly. If you imagine my diagram, another line with a UK company with a UK subsidiary and also shareholders, then the dividends paid by the UK subsidiary were exempt from corporation tax. That's right. That's the different treatment that led to the problem, what is called D5, because historically it was taxed under Schedule D Case 5 many years ago.
When you say the period concerned, what period are we talking about?
Well, I haven't come to ACT yet, but as far as corporation tax is concerned, in 2009, the UK moved to a system of exempting foreign dividends. So the discrimination went away in 2009.
When did it start?
We go back to 1973 when the UK joined the EU. So the claims.
So the D5 charge was in place from 1973 to 2009.
It was in place before then, but we weren't in the EU at that time. So from 73 exactly. So we're talking about for the BAT claims stretch back to 1973, which is why they're so large, mainly because of the interest.
Yeah.
On which at one stage in this litigation you may have seen was compound interest. In fact,
Sempre metals.
We've got Sempre Metals, Prudential, and now it's not compound interest. But when it was compound interest, then the amounts were absolutely enormous. So that goes back to 73. The ACT claims also go back to 73 for two reasons. One is that's when ACT was introduced, coincidentally, but also that's when we joined the EU. So the ACT claims arise from the fact that if you get a UK dividend from a UK company, that is treated as fact investment income and gives you a credit for when you then pay a dividend on to your shareholders. So you don't pay any ACT when you pay on to the shareholders. Whereas if you receive a foreign dividend, that was not FII, and therefore the UK company, in my example, would have to pay ACT. And it's that difference of treatment, when it comes down to it, that is the difference that resulted in the breach of European law. So the FII claim is related to incoming dividends. The Hurst claims relate to dividends paid from UK subsidiaries to foreign parent companies.
Yes, it's the other way around.
The other way around, outward payments of dividends, or put another way, inward investment by the, let's say, the German parent in Hearst, in Mittelgesellschaft. The German parent made established a company as a subsidiary in the UK. And what those claims were about was the fact that when a UK company paid a dividend to its UK parent, it could enter into what was called a group income election, the effect of which was that the subsidiary didn't have to pay ACT on the dividend. But it was not franked investment income. So within the UK, the parent would have had liability to pay ACT. And in practice, in large groups like BAT, dividends were often paid up a chain of UK companies to the very top, all under group income elections. However, the Hearst litigation was about payments abroad, and the complaint was a foreign, if you pay to a foreign parent, you can't make a group income election, and therefore you have to pay ACT.
So if I understood this correctly,
That was the complaint, which was upheld by the European Court.
the FII claims, both for D5 and the ACT, are examples of FII claims.
Yes, they are the FI
And
claims.
the complaint there is you have UK companies, but its subsidiaries are treated differently depending on whether they're UK subsidiaries or EU
No,
subsidiaries.
the UK company is treated differently depending on where it gets the dividend from, because it's the UK company that is taxed or not taxed.
Sorry. UK company is treated differently depending on whether it has UK subsidiaries or EU subsidiaries.
Yes, that's right.
Whereas in Hearst, the complaint is that the UK subsidiary is treated differently depending on whether it has an EU parent or a UK parent.
Exactly. Exactly.
Thank you.
And so there are two, and we'll see this in the case law, there are two ways in which freedom of establishment can arise. One is, and I'm illustrating it by these two cases, one is the freedom of a German parent to establish a subsidiary in the UK. And that can be restricted by what the UK does in relation to that establishment. And Hearst is an example of that. The UK said, well, if you do that, you will have to pay ACT on dividends paid to the German parent, whereas you wouldn't pay ACT if you had a UK company establishing a UK company in the UK. So that's an example of that kind of breach of freedom of establishment. The other type is where, the example of the FII, the UK company is restricted in establishing a subsidiary in another member state by the UK, in this case, the UK tax provisions. They make it less attractive to, in principle, to form a subsidiary in France than to form a subsidiary in the UK because of the discriminatory tax treatment. That's the basis of it. Yeah. So there are two ways in which freedom of establishment can apply. And what we will see is that the first way, the Hearst way, was first identified in relation to tax, certainly in a case called avoir fiscal. It's commission in France, but it's referred to always as avoir fiscal. Partly because there were a lot of commission in France, as you can imagine, as there are a lot of commission in UK cases. So that was identified in avoir fiscal. Subsequently, in about 1990, in Daily Mail, the court recognised that you could have the other kind of restriction of freedom, i.e. outward establishment rather than inward establishment. And that's quite important in this case because that is the kind of establishment restriction that we would be dealing with in the present case. So you'll have seen the Hearst claims, and they succeeded in the European Court in about 2001. And as a result of that, a completely different GLO, which is referred to as the ACT GLO, was formed. And there was a lot of litigation within the ACT GLO. including Semprametals was one of the cases, Pirelli, which you've seen, I think it's in the bundle, and DMG. DMG was a case within the ACT GLO, and they were all in different, what were called classes within the GLO, which were all intended to deal with different kinds of points that arose within it.
Was AXA not also ACT?
No, it's not. AXA is a dividend,
Oh, yeah.
CFC and dividend case. It may have, for all I know, I don't think, I doubt it, because the difference between the dividend GLO and the FII GLO is that in broadly terms, the FII GLO concerns groups, so generally 100% subsidiaries at least, whereas the dividend GLO concerns what's called portfolio dividends, portfolio holdings, which is under 10%. And so they're mainly insurance companies or funds or something.
Yeah.
And the one difference between the big difference between FII and the dividends, the portfolio dividends, is that the portfolio dividends did not receive credit for underlying tax, because it was thought, I think, too difficult to deal with it. But that was held also within the litigation to be a breach of European law, possibly more of a breach, maybe, than FII even, but it doesn't really matter. So that's these two. Then part of the ACT GLO was something called ACT Class 4. And that was dealing with the situation which you have seen mentioned by Mr. Gammy and in cases where a UK company paid a dividend to a foreign parent. In certain cases, under certain double tax treaties that have been negotiated, the foreign parent was able to claim a tax credit. Yeah. Essentially a payment of cash by the UK to the foreign parent. But that was a matter of agreement between the various states. So there were some treaties which didn't give any tax credit. I think the German treaty was an example of that at the time. Whereas, for instance, the Italian treaty did provide for tax credits. And ACT Class 4 was dealing with an argument. Well, there were two arguments, I think, broadly speaking. One was what's called the most favoured nation argument, which was essentially, if you're a German parent, you should be entitled to the best credit that is given to any other member state by the UK. So the argument would be you're being discriminated against because you're a German rather than a French or an Italian. So that was the argument. The other argument was UK parents receive a tax credit when dividends are paid to them. Therefore, we ought to be receiving, we're being discriminated against because we're not getting the credit that UK parents get. So those were, broadly speaking, the two arguments. And they were raised and hushed. You can see that, and you can see discussions about that in the documents at the time, because these were arguments that had been around for years, going back to the early 1990s and possibly beyond. They were raised and hushed. They weren't decided by the European Court and hushed. I'll come back to this perhaps, but the reason was simply, for some reason, the court was told that if they decided issue 1 in favour of the taxpayer, issue 1 being the group income election point I was mentioning, if they decided that, they didn't need to deal with the other point. So they didn't, because they were told it didn't arise. However, it was later litigated in ACT Class 4, and in fact, the case ACT Class 4 and FII went together in a sense that they were heard very close together, I remember. A week apart, I think it was, yes. And they were decided maybe on the same day, I can't remember. Yes, yeah. But it was about something quite, as you can see, quite different. So again, we'll come back to that because it's something that is referred to in the expert evidence and in some of the in Mr. Farmer and Lyle book, particularly. The other claim that I think we have to be aware of is the Marks and Spencer claim. And that was something a bit different, which was a loss relief. UK groups, companies within UK groups can surrender losses to other companies in the group. Essentially, the idea being that although they are separate companies and they're taxed separately, the group is a single economic entity. And so, if you make losses in one part of it, you ought to be able to set them off against profits in another part, and that's what you can do in the UK, within the UK. It wasn't possible, however, to surrender losses from a foreign subsidiary to a UK company. It could only be from a UK company. You may say for obvious reasons, but anyway, within the UK certainly it made sense. However, Marks and Spencer was the case which challenged that and said that actually is a breach of European law. We made losses in our French subsidiary. You may remember Marks and Spencer's closed a lot of stores on the continent, in Germany and Belgium and France. We made losses there. We ought to be able to relieve them against the profits in the UK.
What was the basis for that challenge? That was what? Freedom of
establishment. If we establish...
Explain that one to me.
I think broadly the argument was, Mr. Williamson could probably... He argued the case. The argument was, you've got a UK company. If you establish a subsidiary in the UK, they can surrender losses to you or within the group. If you establish a subsidiary in France, they can't surrender losses. Therefore, you are discriminating between establishments in the UK and establishments in France.
But also you could, sorry.
Yeah.
I was going to say you could operate your French shop through a UK subsidiary because there are different ways in which you can establish branches that operate overseas, and my understanding is that part of the freedom of establishment is you have a freedom to choose whether to operate through French subsidiaries or UK subsidiaries, even when you're running a business in Paris.
Yes.
So when you close the Paris shop, if it makes a difference whether you've run it through a French subsidiary or a UK subsidiary, that's a restriction on your freedom to choose your form of establishment.
That's right. That was the argument.
It's a freedom to choose when you're establishing a company on the basis that it will make losses and you might have to close it.
Well, it might make losses. I mean, these what you've got to remember, I think, my lord, is that the breaches of the freedom of establishment restrictions are restrictions only because of the tendency. So you may say, well, nobody in real life is going to worry about whether they can relieve losses. But that doesn't matter, it's the tendency, because we're looking at the single market. And so even the...
Was it always put on the basis of freedom of establishment, or sometimes on the basis of free movement of capital?
Yes, it can be. These two provisions are not the same.
No. Sorry.
Although very similar principles apply. Freedom of movement of capital only goes back to 1990, because that's when the provision came in. Whereas freedom of establishment's been there the whole period since 1973. Freedom of movement of capital also applies between member states and third countries. But there are various complications in that. There is a standstill provision, for instance, which allows restrictions which existed in 1993 when they introduced a provision in, I think it was Maastricht, to extend it to third countries. There is also a question which freedom is engaged in a particular case. And what the court appears to have said in its case law is, if you have a situation which only applies within a group, so for instance the group income elections, or the surrender of losses, then it's only freedom of establishment that is engaged in that case. And that's why the Marks and Spencer's claim they can make it outside the EU. And similarly, all the cases like thin capitalisation, which involve groups of companies, they can't make them outside the UK. But you're right, my lord. There is a parallel freedom of movement of capital which can apply. And indeed, I think we'll see that was the freedom that the court actually applied in Verkuyen.
That's exactly what I was looking at, which is why I asked you.
Oddly, though, when we look at the earlier stage in Verkuyen, in the Dutch courts, they relied on freedom of establishment, but said it would probably be the same under freedom of capital. So, in a case like Verkuyen, either freedom could apply, and the courts have said that in cases like FII, either freedom can apply. So, if you're dealing with third countries, then you can apply. You can rely on free movement of capital. There is no advantage within the EU in relying on free movement of capital if you can rely on freedom of establishment. So yes, so the Marks and Spencer's claim, yeah, that was the argument, and this is very important actually because Mr. Gammy in his evidence says, you can see my view on comparability between non-resident and resident subsidiaries by the decision which I made, well, it was two people in five, but the decision I wrote in the special commissioners in Marks and Spencer's. Because the very first stage of Marks and Spencer's, and I'm sure Mr. Aronson remembers it vividly, was the special commissioners.
And that was Mr. Gammy.
And it was Mr. Gammy and Mr. Avery Jones, but in fact, Mr. Gammy said in his report that he wrote the decision, and I think everyone probably suspected that was the case. And what they decided was that there was no breach of freedom of establishment because the non-resident subsidiary and the resident subsidiary were not in a comparable situation. That was the decision. I noticed we don't actually have that decision in the bundle. I'll maybe arrange that we have it so you can actually see it, but particularly as Mr. Gammy referred to it and said, you can see my view from this decision. But that's what he thought. And we're now talking about, of course, 2004 when he made that decision. He thought these two are not comparable. Now, when it came to the European Court, they didn't say that. They simply said there was a restriction. I don't think they even addressed the issue. But it was quite clear from the decision that they were comparable, or they were regarded by the European Court as comparable. And that is why, in my submission, you will see, that's why Mr. Gammy maintained his position that they were not comparable, right up until 2005. You see in his report. His position was there is no breach of freedom of establishment because the non-resident subsidiary and resident subsidiary are not comparable. And for there to be discrimination or difference of treatment within European law, that you have to be giving different treatment to comparable situations. So that was the reasoning. So yes, that's the significance of Marks and Spencer's. That it was important to Mr. Gammy, certainly, as far as his evidence is concerned. I'm going to come back to all this as to what Mr. Gammy was actually saying, but that explains, I think, what Mr. Gammy was saying. That's what he says in his report, in fact. He says that it wasn't until Lensman and then finally Marks and Spencer's that you had the final stepping stone, and you finally knew, he finally knew, certainly, that the two subsidiaries were comparable, dividends from the subsidiary were comparable, and therefore FII could succeed, or probably would succeed, I think, at that stage. So, Lensman and Marks and Spencer's, yeah. So, you will have seen that the foundation of the test claimant's claim for restitution in this case is they paid money under a mistake of law. That was a mistake which always existed. As the Supreme Court said, this is not a case of a deemed mistake. by which I think they mean a case where the law was one thing because there was a decision of a court saying the law was X, and then it subsequently overruled, saying the law is Y later. I think that's often referred to by judges and commentators as a deemed mistake, because when you made the payment, you were making it under the decision that had been made, but subsequently it's shown that that was wrong, in fact, and therefore you did make a mistake. But that's not this case. So the sole question, I hope, remaining in this lengthy litigation is when that mistake could have been discovered. And as you will be aware, the Supreme Court in FII Supreme Court 2 departed from the previous case law of the House of Lords, determining when a mistake of law was discovered for the purposes of section 32(1)(c), and therefore when it was discoverable. And it aligned the test, the construction, closely with the approach found in other parts of the Limitation Act. And it ensured by this purpose of construction that the underlying purpose of the Limitation Act, to provide certainty to defendants and to limit litigation, as they said, was protected. So you had quite a contrast. You had the DMG decision, which was taking in a sense, the provision literally and saying, well, you couldn't discover your mistake until you knew the truth, and you didn't know the truth until the final decision in that case, which by the highest court essentially. And Supreme Court 2, which said, well, that can't be right for various reasons, and that produces a paradox. It puts mistake claims, both mistake of law and mistake of fact, I suppose, completely out of line with the rest of the Limitation Act. And you'll have seen they refer to cases. We'll come on to like AB in the Ministry of Defence, where limitation has been held to start at a time when the claimants had no way of knowing that they were going to win. In fact, they didn't win in the end. So that was what the Supreme Court did. And the judge in this case, as I said, was the first to have to grapple with the practical implications of that purpose of construction. And in particular to grapple with the implications of the Supreme Court's clear statement that it's not the final judgment that determines the question of discoverability. And he was the first to have to consider, in the light of Supreme Court decision and the evidence, when a particular mistake of law was indeed, when it was discoverable. Now you will have seen that we say that the judge went fundamentally wrong in his approach to what is admittedly a difficult question. You can see that from the Supreme Court decision, but also from the split in views in the Supreme Court, because I'm sure you'll have seen that three of the justices concluded that Section 32(1)(c) just shouldn't apply at all to mistakes of law.
Well, that ship has sailed.
So that ship has sailed. Yes, I understand that, but the only point I'm making is that the point they were making was that this is a very difficult.
Yes, that's one of the things that they said is it's a very difficult test, and how are you going to be able to apply it in practice? And you say QED. Yes, well, as you say, that ship has sailed, but it may be that the wisdom of their position might be being revealed. No doubt
so
in
that
the
doesn't
future
matter.
they will tell us.
Doesn't matter. My point simply is that there's no doubt that this is a difficult, and it's a novel question, because it's never had to be asked before in this way. Dealing with mistakes of law rather than mistakes of fact or other limitation issues, which usually depend on questions like when were the claimants able to find out particular facts. That's normally the kind of situation. But here, and these facts might have been difficult to discover or hidden in some sense, or But here we're dealing with law, and that's always the fundamental problem with this, that law is not, in essence, it's not hidden in any real sense. So you're asking a difficult question. But we say that although he purported, at least in parts of the judgment, to apply the guidance, in substance that he didn't do so. And as you know, to some degree, and no doubt we'll come to this in the next few days, the fact that the judge went wrong is common ground, at least between the revenue and some of the test claimants, because you also have a cross appeal or an appeal before you from FCE, who failed, of course, on the basis of the judge's judgment, because their claims
He picked
were
a
brought.
date that was too early for them.
It was too early for them.
What was the judge's date?
2001.
It was Verkuyen.
The handing down of the judgment.
The handing down of the judgment in Verkuyen, which is in
And what-
2000.
2000.
In 2000. I'll
2000.
give you the precise date. It was in 2000. I was going to come on to looking at these cases, but it was in 2000. Their claims were brought in 2007. And there were also another lot of claims, EMI, whose claims were brought in 2009, who were part of the original trial. They have given up, so they didn't appeal, because they would have to show that the date was sometime 2003, possibly after the claims were brought.
But are there a lot of people in the same position as FCE?
I think, looking at it, I think there are actually only two, FCE and one other. Yes, in their position. There were obviously quite a number of people in the position of BAT who brought claims in 2003, 2004.
So who succeed on the judges?
Who succeed on the judges, but
Judgment which you're
appealing.
by your appeal trying to knock them out as well.
exactly. Yeah.
And if you succeed in you're arguing from 1996, I think.
That's
at
right.
the latest, and that knocks everybody out, doesn't it?
Yes.
That's right. Yes. And just to be clear, I think the judge makes this point that that's the reason that we've chosen that date. We're not saying that.
You're not saying something happened in 2006, 1996, which makes all the difference.
We're not. No. We're not saying anything happened in 1996.
You're
We're
saying by no later than 1996.
yes. We don't have to. We don't have to establish, or rather,
You don't have to establish anything.
we don't have to establish anything. Yes, but we don't have to. We don't have to. We don't have to knock down their case in relation to any date before 1996. So we don't have to argue that. I mean, in fact, I think in relation to the factors that we think are relevant, which are what the cases were decided before then in the European Court, relevant principles that were decided. I'm not sure that anything really much happened after about 1993. That doesn't matter. We are focused on saying, well, you look at the position in 1996, which I think must be the right approach if that's the relevant date for limitation. So it's, yes, 6th June, I'm told. Was for Kuyen.
6th of June
Kuyen was
2000.
decided on the 6th of June
2000.
2000. But the position of the test claimants, we'll have to hear what they say, but there does appear to be a tension, as far as we can see, between the arguments FCE are putting forward, which is that it couldn't be discovered at Verkuyen, but it could be discovered at Hurst, which is 2001, and the position of the other test claimants, which is to uphold the judge's decision, I think. Because the judge's decision was, it was discoverable at Verkuyen when that decision was handed down.
Can you just remind me why the Advocate General's opinion in Verkuyen isn't thought to be a significant date?
Very good question. I don't know. Well, I don't say I don't know, but it's not part of my case that it's not.
Okay.
We say.
Has anybody? It may not be part. I appreciate it's not part of your case, Is there an answer somewhere in the papers as to why the judge or anybody didn't land on the date of the advocate? Because the Advocate General gave a lengthy opinion, admittedly I think in Italian, but nonetheless, which was then upheld by the court.
Yes. Well, it's slightly more complicated than that, remember, because there were two Advocate General opinions. He gave one, and then he was.
That's right.
Then he realised he was told that he'd got the facts wrong. About
and then he gave another one. But that's still a year earlier. I think.
Yes.
Is it a year? Yeah. Well, 6 months, some months. Anyway, but nobody seems to have, or at least. Anyway,
we
okay.
say focusing.
We'll get to it.
Yeah, we'll get it. We say focusing on these things is the wrong approach in any event. That doesn't. That they don't make any difference. Don't make a difference. That's going to change things.
But the judge didn't explain. The judge's date was for QE in the court.
It was. Yes. He didn't explain why.
Why it wasn't the Advocate General's opinion.
And of course, that point arises very acutely in the FCE appeal, because the Hurst Advocate General opinion is actually too early for the FCE.
Yeah, I appreciate that.
And we say, well, how can you possibly say if you're right, that Hurst made all the difference and that you wouldn't have been alerted by the Advocate General opinion? That's I think a more difficult question. But I mean, this raises the problem in the way that the judge, and indeed I submit the test claimants, have dealt with the evidence. It's slightly peculiar, because the judge started off by finding, you've seen the professional consensus, which he talks about, and he found that entirely from Mr. Gammey's evidence. Mr. Gammey gave evidence that there was an assumption. We'll come on to what exactly he said, but there was an assumption. And he found, therefore, that any advisor at that time would have simply followed that consensus stroke assumption in the advice that he gave, the notional advice he gave to a claimant at that point. So that is dealt with on the basis of the evidence of Mr. Gammey, not on the basis of an analysis of the case law up until that point, which we would say would be the appropriate thing to do. And I'll definitely be coming back to that and doing that.
Well, I mean,
but then
at some point you're going. I mean, the question of what the appropriate approach might be will depend on what the Supreme Court judgment actually requires.
Yes.
Because if it is a question of fact, it's an unusual one of fact, but it's what people actually thought based upon legal cases. But if the question is one of fact, then your challenge has to be so much stronger to overturn the judge's assessment of fact. If it's actually all a question of looking at case law, then in a sense this court is in as good a position as the judge was. But then why did he, he heard the parties obviously thought it was relevant, put a lot of evidence in front of him as to what the state of understanding was at the time.
But it depends on it begs the question of what is actually meant by a worthwhile cause of action, doesn't it? I mean, that's the nub of this.
That's one of the important issues. What is the standard that you have to apply?
What is meant by worthwhile in this context? And in order to determine what is worthwhile, we're bearing in mind that the Supreme Court has said that this decision has ramifications well outside the tax sphere. And what they're trying to do is to have a logical internal consistency in the way in which different types of claims are dealt with within the sphere of the Limitation Act. And so if you're looking at parallel situation, it's at what point does somebody discover, or could they reasonably have discovered, that they have a cause of action? And if you look at it through that lens, then it can't just simply be looking at what the case law says, but you've got to look at it through the lens of a multinational or reasonable multinational conglomerate, which is going to take some kind of advice, because the CEO's not going to know and he's going to go to somebody. and they will no doubt look at the law, but they will also be part of a body of people who look at the overall position, and there may be assumptions and there may be positions. So I don't think it's all as straightforward myself as just looking at the case law.
That may or may not be correct. I mean, can I just deal with a few points that arise from that? First of all, in answer to Lord Justice Snowden, the first point I would make is, and I'll come back to this, that it is said to be an objective test.
Yeah.
A number of times by the Supreme Court. So the question is, what does that mean? I would suggest that means that it's a question for the court to decide on the basis of the evidence. Going back to my lady's point, first of all, you've got to be very careful about this. It's not whether you've got a cause of action. What the Supreme Court makes clear is what we're looking at is just a mistake. Could you discover the mistake? Yeah. Whether you've got a cause of action can depend on a whole lot of other things. And we'll see, for instance, the Supreme Court make the point that before Climate Benson, of course, you might not have been aware that you could bring a mistake of law claim at all. But that's irrelevant to this consideration. If you could discover the mistake, the fact that it was not seen at the time that you could bring a claim will not help.
No, I think I was making the point that one's trying to look for logical coherence in the approach. So it is a different test. The test is, could you have discovered a mistake rather than could you have discovered a cause of action? But then one adds in that qualitative assessment of worthwhile, which sort of blurs the edges, doesn't it?
Well, I think what you do have to consider, though, is the other ways that the position is formulated by the Supreme Court, because simply to concentrate on worthwhile without looking at the others.
But then they say, well, they mean the same thing.
Well, exactly. That's exactly the point. So in deciding what worthwhile is, you have to look at what they say about it otherwise, to interpret what's meant by a worthwhile claim, and also what they say about the fact that claims, for instance, that completely fail, or would be struck out, can be, the limitation period will start to run despite the fact that the claim, in other words, you don't wait until you've got a good claim.
No, the claim may not succeed. The fact that the claim may not succeed would never be an answer to a limitation point, even if you were going down the other branch of looking to see whether you had a cause of action. You've either got a viable argument, the argument may or may not succeed at the end of the day. On the striking out, I think there may be a difference depending on what is meant by worthwhile, but we'll see how the argument develops on that. I see how you put it. Yeah.
The problem with this is there are all sorts of different words that you can use. Viable, claim, etc. And what do they mean exactly? That's the difficulty. But yes, that is an important part, I would suggest, of this case. So can I then just explain how I'm going to structure the submissions? And the first is, I hope, not surprisingly, to look at FII Supreme Court 2 itself. What was the court saying in that case? What was it aiming for? And as my lady has indicated, the test was laid down in a number of ways. One is, and we see in one, they say, knew or could with reasonable diligence know that he made a mistake with sufficient confidence to justify embarking on preliminaries to the issue of writ, such as submitting a claim. And then they say, recognising a worthwhile claim arises, and then they say these being the same, and they should cast light on each other. It's also described, which I think I find particularly more helpful in the context of a mistake. Because of course the problem is that we're not actually looking at the claim, we're looking at part of the claim. We're just looking at whether your argument that the EU law, the tax provisions were overridden by EU law or contrary to EU law, whether that part of the claim is worthwhile or is sufficient, you have sufficient confidence to justify embarking on these stages.
What does it boil down? Does it boil down to being alerted to the fact that there is a viable argument that these provisions are contrary to EU law?
Yes, well, the other way that it's put by the Supreme Court, we'll see that, is to ask whether at any point the basis on which the payment was made was legally questionable. That's what they say. So that may be another way of putting your ladyship's point. Is there a viable argument in the sense of not one that's fanciful or going to be completely just knocked out?
You've got a decent argument.
You've got some decent argument, yes. But it doesn't have to be anywhere near 50%. That's, I think, the crucial point. And it doesn't have to be that the advisor would say to you, the notional advisor, supposing the notional advisor said, I think you've got a viable, an arguable case, but actually I think, personally on the law, that you will lose.
Yeah.
That obviously does trigger the limitation period. That would, for certain. Because the fact that you're told, you've now been alerted to the fact of the mistake, the possibility of the mistake.
But if the consensus of professional advisors would be, this is absolutely hopeless, you couldn't argue this, you'd be laughed out of court, then you wouldn't have a viable claim.
Absolutely, I agree. And in fact, that would be the sort of obverse of the case of ignorance that these people talk about, which is the ignorance cases where you'd be told, you've obviously made a mistake. Clearly, what you did was wrong. Yeah. Whereas the opposite would be, yeah, it's hopeless. Now, I agree, if that were what people thought, but of course, it wouldn't be enough simply for someone to say, well, advisors thought this was hopeless, full stop. You'd have to have a reason, obviously, as to why it's hopeless. And the court would obviously have to look at, in assessing that, to look at the reasons why it's hopeless. It should be obvious. I mean, the reason, if the consensus is it's hopeless, it would have to be for a very good reason.
Well, why? Because you're relying on your reasonable advisor, and they could all be barking up the wrong tree because they haven't actually seen a clever legal point that might occur to the ECJ. And it may well be in the light of hindsight that it turns out that they're all completely wrong. But if the received wisdom at the time is this is absolutely hopeless, why does that have to be why do you have to add this extra layer of reasonableness to it?
I'm simply saying that well, let me put it this way: if you went along to an advisor and he said, and you said, I'm thinking of mounting a multi-million-pound claim against the revenue, hundreds of millions. Can you tell me whether it's good or not? And he says, sorry, it's completely hopeless. You're not going to say, thank you very much. You're going to say, well, why is it hopeless, presumably? And the advisor will have to tell you why it's hopeless. So that's the point. And the court cannot assess this on the basis that everybody in the world of advice is going to give irrational advice. Now, I'm not suggesting, my lady, that they should act with hindsight and advisors should be able to predict, as you say, unexpected or clever arguments that the European Court might come upon some way down the line. You're looking at the position at the date as to how it would be assessed. But we're not remotely in that. In this case, you may be theoretically right, but we're not remotely in that ballgame in this case, that these were regarded as hopeless arguments. It's not even close to that.
You put in your example that you had a multi-million-pound claim. Does the size of a claim make any difference to the analysis? Either you've got a decent argument or you don't, and the size of the claim shouldn't affect the quality of the argument.
Can I put it this way? I would agree with your lordship, because I would submit primarily that this is an objective assessment that the court would make, looking at the legal position as it was as it would have been understood.
As it would have been understood at the time, but the legal position. If I have a claim for breach of contract, it doesn't matter to the quality of the argument whether the claim is for 100 million or for £10.
No.
the legal analysis ought to be exactly the same. And it leads on to another question, which is, sometimes when you say something is worthwhile, you're talking about a cost-benefit analysis. Is it worth spending the money to get a,
Yes.
and the quality of, how good, what's your percentage chance and how much it will cost you and so on, feeds into that analysis. But that's
not this case. That's not what this is talking about.
That's not what the Supreme Court mean by worthwhile. They don't mean it's economically worthwhile. They mean it's legally got some
legs.
It's got legs.
It's got legs.
Yeah. No, I agree. The reason I say I agree with you, because I think that's the correct way to do it, is because what the judge did was go into a different approach, which was to imagine going to what he regarded as a real world situation that would have happened at the time, and asked, well, if you ask one of these people who had these assumptions and whatever consensus, that's what they would have said. They wouldn't have looked at the case law and done an analysis. They would have acted at a high level. I would say that's completely the wrong approach the judge adopted. But if you're going to adopt that approach, you've got to see it through and be realistic about what would actually happen in getting advice. You cannot say that these people would have accepted advice without questioning it. That's just not realistic. That's what I'm saying. I'm not saying that is the correct approach you should be taking. I'm saying the court, it's a much simpler approach. The court should simply be looking at what was the case law. Look at, agree, if there were commentaries by experts, you would obviously look at that, as any court would. But of course, even they are only as valuable as the reasoning in them. No court is going to say, well, I'm going to follow Professor X because he's Professor X. I'm going to follow Professor X because his reasoning is cogent. That's what courts do. And that's the same approach that you should adopt, that would be adopted here. So if there were, and in fact there weren't in this case, but perhaps surprisingly, I don't know. But if there had been a whole lot of academic and practitioner articles discussing this issue and coming to conclusions based on the current case law at the time, then of course that would be something that the court would take account of. They would look and see, this is what X said, and
I wonder, because once you've got a debate and the issue's been recognised, then it makes it easier for you to say there was a viable argument, because regardless of which side of the debate you were on, it had been recognised that somebody could put forward a case without blushing, should we say, that there was a mistake, or that this was all contrary to EU law. So you've got a debate going on amongst academics about this point. The point's actually got to have been raised in the academic literature, and it's got to have been debated. Well, the question really is whether or not they've been alerted to the fact that there's a point.
I'll come back to that, but it's not a question of alerting, because the way that the test works is that you have to assume that the claimant wishes to discover whether they made a mistake or not.
Yes.
So you're not asking, was there something that would have alerted them to the possibility of the mistake? That's not, and the judge deals with it in that way. He doesn't look for alerting.
You're assumed to be a quite well-resourced company that's looking for advice. You're not assumed to be sitting there in a state of ignorance.
And trying to find out whether they made a mistake. You don't have to ask the question, well, was there some reason for them to seek advice?
Are they trying to find out whether they've made a mistake, or are they trying to find out from their advisor whether there's any way that they can avoid this tax problem?
No, what the courts, I'm going to come to this, what the Supreme Court says is that they're assumed to be wishing to discover whether they made a mistake or not.
Okay.
Because, of course, what the court is talking about doesn't just apply to tax. I mean, it's overruling DMG for any mistakes.
Have I paid money under a mistake?
Yes.
When I shouldn't have done?
Yeah, it could be any kind of mistake.
But I make payments all the time. I'd always like to know whether I've made any payments under a mistake. You have to have some sort of trigger to make that inquiry, or else we'd forever be saying, well, I paid something last week. I wonder whether that was a mistake, or, I mean, there's got to be some trigger.
No, because what we're looking at here is the start of the limitation period, and when you could have discovered that you made a mistake in the relevant sense to start the limitation period. And
what could with reasonable diligence, or could?
The point, we'll come to what the Supreme Court says, but they make it clear that the idea of reasonable diligence has built into it an assumption that the claimant wishes to discover whether they made a mistake.
All the time, for every payment they've ever made.
You're testing it.
All the time. So the law is that everybody is always thinking about whether they've made a previous payment under a mistake.
Well, the law is when you decide whether it was discoverable.
Well, perhaps okay.
Then you do assume. Then you test it by assuming that, and you don't ask a first question, which is, was there something that happened that would have made them want to think about it? That's not the approach, the correct approach. Okay. Because the problem with that is, when you think about it, the problem with that is that even in cases of complete ignorance, I mean, supposing you make a mistake, which any lawyer would tell you was wrong, but you, for some reason, think that you're liable to make a payment. Nothing might happen for years.
You can't rely on the fact that you sat on your hands and didn't ask for the advice.
And you didn't ask for it.
Point.
Yes, exactly. That's the point. Otherwise, you could say, well, nothing alerted me to this until somebody in the pub told me, 5 years later, that I might have made a mistake, and therefore it wasn't discoverable by me. But
so your starting point is, if I had sought advice at the time as to whether I'd made a mistake, could I have, with reasonable diligence, have ascertained that I did?
Yes.
Or might have done.
And because of the oddity of this being a mistake of law, it inevitably has to involve legal advice.
Yes.
Which is why it's all very odd. I mean, it is an odd position, a test, but it's forced by the logic of it being a mistake of law and 32(1)(c applying. So you have to apply that approach, and that's what the judge did. He didn't ask if there was something which would have caused them to think about it, because that would be a wholly different question, of course. You'd then be asking, well, how well publicised were various things? Would something have...
So I take it from that answer, Mr. Hewitt, that you're not criticising the judge for introducing this idea of the hypothetical lawyer into the equation as an unwarranted gloss on the Supreme Court judgment, because inevitably, if you're trying to look out at whether there's a mistake of law, you've got to get to a professional and ask them about it.
I'm not criticising the idea of using what I might describe as a thought experiment in order for the court to try and decide the case. When the appropriate advisor or the advisor is not part of the Supreme Court decision, but it is a useful tool.
Yeah.
But you've got to bear in mind that it's only a tool, and in the end, it's a decision for the court as to whether, objectively, the mistake was discoverable at that particular time. And that has to be the case. That's the case because that is the most practical way of dealing with these cases. The idea that you would have practitioners retired practitioners coming back and giving evidence that they would have thought something and some of their friends would have thought something, and people they knew, and then someone else saying, well, actually, people I knew thought something different. Just cannot be the way that these cases have to be decided in principle. It would be nonsense. And if this approach was upheld, that's what inevitably is going to have to happen in the next case.
But how else do you discover that the law is not what you thought it was? Apart from asking, what would a lawyer have told you?
The question is, could you have discovered it? That's the question that's being asked. And if what was there in the law was such that you could have discovered it, then that answers the question.
But it could have discovered with appropriate legal assistance.
It would have to be with
So why doesn't that build in the notion of? I mean, did you say at the time before the judge, look, we shouldn't be having any expert evidence here at all?
Well, I don't think we could do that because the Supreme Court indicated, and there was an order from Mrs. Justice Falk that she was in. I agree. I was going to come back to this. That it is odd to talk about expert evidence in this context, but it's. The question is, what did the Supreme Court mean when they said it might be assisted by expert evidence?
Because they were probably envisaging that since it's a mistake of law, in order to answer the question whether it is discoverable, you probably have to consult a lawyer, don't you?
But we've got the court is as I think you said, is exactly the same position. The expert evidence is about law essentially.
But the court doesn't.
Yes, but it's not about what the law now is. It's what the law was on a particular date. And
yes.
However much we might think we know what the law is, it's much more difficult for us to know without assistance what the law was 20 years ago or
was thought.
Well, it was thought to be. It's what the law was thought to be.
It's actually a question of fact.
Yes.
What did people think the law was at a previous point in time? I mean, that's really what discovery
Well, I think there was a way of challenging the
It's what people would have thought the law was if they had been asked. I mean, in this case, as you'll see from the evidence, it's rather strange. Nobody had thought about what the law was at that time. That was Mr. Gammy's evidence that he kept saying this, that people didn't think about it. Now, his explanation for that was because they assumed something. This is not a case where you can go back and see what people actually were thinking because they were discussing it or they actually had considered the point. I quite agree. If you had evidence from somebody who said, I considered the point in 1995, I looked at all the cases and I came to this conclusion, then that would be, you could see that would be relevant evidence.
Well, it might be, but I wonder how far it would take you, because then it would be said on your side, well, the fact that this particular individual would have said it's hopeless is not going to help, because you're looking at an objective test, and the fact is that somebody else might have taken a different view, and therefore the point was out there and the mistake was discoverable.
Well, I didn't say it was conclusive.
No.
I simply said it would be relevant. It may depend on what the reasoning was and how particular cases were perceived at the time. It may be that this person says, look, I gave this advice, I thought that this particular case had this effect at the time. Now, we've now discovered subsequently, of course, because the European Court has said other things, that in fact it didn't have that effect. But that's what I thought at the time. Because look at the case, it says X, Y, Z. Now that would be relevant. I'm not suggesting any of this is conclusive, and none of this should be conclusive as to what the answer is, but it's relevant.
And do you accept that when you say, well, at what point in time was it discoverable? That's the question. Objectively, which means that you are looking for something other than a particular person's point of view, but you're looking objectively, I understand that, without the benefit of hindsight.
Yes, of course. You're looking at absolutely. You're looking at the position as it would have been with the state of things as they were in that particular time. So you can't look at subsequent developments in the law, obviously, or explanations of previous cases subsequently.
So why isn't that a question upon which evidence from people who were in the profession at the time would be relevant?
It could be relevant, and in cases where they were advising on this, obviously it would be very relevant.
You say they weren't advising on it because Mr. Gammy says that nobody thought about it.
Yes, well that's the point about the evidence in this case. There were no discussions of it, nobody thought about it. Now, why nobody thought about it, maybe what I suggest was simply because nobody thought about it, because we don't all think about everything all the time.
I'm trying to just, before we get into the evidence in this case, I was just trying to understand what you say that the Supreme Court has decided should be our approach. and I'm not sure I now quite understand what you're saying to us. Are you saying that it is a question of fact for the court as to what would have been discoverable at the time if you'd have consulted a lawyer? Which is a question, as I understand it at the moment, of fact. Or are you saying it's for us now, trying as best we can not to apply hindsight, to simply conduct some sort of legal archaeology to figure something out? Because those two things are very different, depending on, and will determine the approach we take to whether to overturn the judge's decision or not, because the test is going to be very different, isn't it?
Yes, I wouldn't say my primary submission would not be that it's entirely a question of fact for the judge to decide, because it is an objective test to decide whether it could have been discovered based on what was there. So it's not truly a question of fact in that sense. So I would suggest.
So you say are you saying it's irrelevant to ask what the legal profession collectively thought at the time?
Well, if you can find out what the legal profession thought, entire legal profession, well, let me put it this way. It doesn't answer the question. What was thought as a sort of general sense. In other words, if nobody was asked to consider the question, the evidence that says, well, nobody thought about it because everyone assumed whatever you say, can't answer the question. For one thing, because if you did take advice, the person you're taking advice from wouldn't have based his advice on an assumption.
No, well, if you'd have asked the question, the person who you asked the question of would have had to think about it.
Exactly, that's the point.
The fact that everybody else, as a matter of fact, wasn't thinking about it doesn't help. I understand that.
Yes.
But
if they had thought about it and they had formed a view at the time, and they can give evidence about that, that would be different. That would be relevant. Could be relevant.
That's what it's been called.
Mr. Stewart, I wrote down at the top of this page the structure of your submissions, and you were telling
Yes,
us
I'm
where
sorry,
your games go. I wonder whether.
Shall I do that now?
Well, I wonder whether this debate about what test the Supreme Court actually laid down is easier for us to have with the text in front of us.
I think you're right. I was going to suggest that. But can I just tell you what I'm going to do briefly first? So I'm going to look at Supreme Court 2 and suggest what propositions come out of that. Then I'm going to look at various matters such as the cases and various articles and the evidence that was given. But I'm going to deal with it in chronological order so that you can see, I hope, clearly when different things happened in relation to others. And that will probably be the main meat of the submissions. Because once we've done that, then you'll have the raw materials. And then I was going to look at the judgment of the judge. And finally, I was going to turn to the grounds of appeal and the cross appeal. Hopefully, by that stage, we'll have covered most of the ground, but we can tie it all together. And I anticipate that may well be tomorrow morning. So, can we then begin with the Supreme Court decision? It's tab 14. If you've got, it's in my volume 2 of the authorities. I don't know if yours are saying tab 14.
Yeah.
Now there's a very long first section dealing with abuse of process and issue estoppel, etc., which I'm not going to take you through. And also something that you have to bear in mind when looking at this decision is that it's doing two things in a sense. One is dealing with a DMG and why DMG was wrongly decided and should be overruled. And in that context, it's dealing with the most extreme position that you find in DMG, which is that you have to wait until the final judgment in the particular case to discover your mistake. But it's also obviously dealing with what it's going to put in place of DMG. What will be the approach that should be adopted since DMG is being overruled? And then there is a third element, which is parts of the judgment, particularly at the end, which are particular to the disposal of this particular appeal. But the first two of these are in a sense rather general, because one of them is saying DMG is wrong in principle, and the second is saying this is the approach that should be adopted, not just in this case, but in all cases of mistake of law. So I was going to pick it up at page 785. Where they begin the discussion of Deutsche Morgan Grenfell, and in paragraphs 173 and 174 and 175 and 176 they discuss the paradox that is created by DMG, which is that you cannot discover your mistake until you have, in a sense, won, in most cases, the case. And they say that that's illogical, and it results from a difference in Lord Hoffman's approach to the accrual of a cause of action and the limitation period applicable to it. And this is in paragraph 174. Essentially, they're saying, as regards the mistake, he transfers it back to the past. A decision at a later date will apply retrospectively. But as regards the discovery, he doesn't apply the same approach. So you then have a mismatch in there being a mistake 10 years before, but the discovery occurs when the decision is made at the end. That's what they identify as being one of the problems with the decision. And they then discuss whether it matters it's a deemed mistake, and they conclude in paragraph 176 that actually that doesn't make any difference. This applies equally to deemed mistakes and to what they call, I think they refer to as actual mistakes. I think the difference is simply whether a previous authority was overruled subsequently. If it was, then they regard that as a deemed mistake, I think. Whereas if there was no authority previously, then they say you made an actual mistake. And just you've discovered it. The mistake has been identified, later. I think that's the distinction they're drawing. So then if we pick it up at 177, they say that thought is reinforced by other considerations. Section 32(1) applies where the claimant cannot reasonably be expected to discover a mistake which forms an essential ingredient of the cause of action. Its effect is that the limitation period commences not on the date when the cause of action accrues, but on the date when the claimant discovers or could with reasonable diligence discover the mistake in question. The result of that postponement of the commencement date of the limitation period is to postpone the deadline for the bringing of a claim, so that the time during which the claimant was disadvantaged by the mistake does not count against them. Lord Hoffman's approach, whereby the limitation period does not begin until the truth has been established by a final judicial decision, does not merely extend the limitation period to the extent necessary to overcome the disadvantage arising from the mistake, but has a remarkable consequence of excusing the claimant from the necessity of bringing a claim until he can be certain that it will succeed, until it's in fact succeeded. That places a claimant in a case based on a mistake of law in a uniquely privileged position, since other claimants are required to bring their claims at a time when they have no such guarantee. The limitation period runs alike for claims which fail as for claims which succeed. And I would say similar, as I indicated earlier, a similar point would arise if you were to argue that you can wait until the claimant would be advised that his claim was going to succeed. So that's not what the approach that they adopt. And then 178, there they talk about the kind of items that might be relevant. So they say if the limitation period can begin at a time when a claim is uncertain of success, then in addition to the logical problem discussed earlier, there's also a lack of realism in treating the date of judicial decision authoritatively establishing the true state of the law as the earliest date, when the claimant discovers or could with reasonable diligence discover the mistake in question. In the first place, the courts do not act on their own initiative, but only when their jurisdiction is invoked, normally by the issuing of a claim. Point of law could often have been decided earlier if a claim had been brought at an earlier time. So this is making the simple point that the law doesn't develop logically by step, and the point at which claims are brought depends on happenstance very often as to when that particular claim might be brought.
I mean,
there's no logic to it.
I mean, does this hark back to a passage I don't think you read to us, with at paragraph 176 on the previous page at H? There,
Yeah.
what Lord Reid says is, on the limitation side of the analysis, on the other hand, the concept of discoverability is designed to protect claimants who could not reasonably be expected to know the existence of the circumstances giving rise to their cause of action until some time after it accrued. It must therefore be concerned with discoverability in reality at a date which may be later than T1. I mean,
Yes.
Is
T1 being the date of the mistake, original mistake, payment.
Yeah. I mean,
Yes.
he talks there about discoverability in reality, which I think is what he comes back to at 178, isn't it? I mean, that he's not just talking about a sort of conceptual legal analysis, is he? He's talking about discoverability in reality. In other words, was it discoverable in reality at what time?
I think he's dealing with an argument, which is that the law is always discoverable, essentially, and so you might say this could be an answer. You might say, well, at any point in time, you could have discovered what the law was, because after all, the law is not hidden. You can discover it. What he's saying here is no, that's not that theoretical approach is not right. You have to look at whether, in reality.
Yeah, I'm just trying to set the scene for when we come to look at his later test.
Yes. Yeah, and I agree with that. You couldn't simply say, well, in 1974, in principle, somebody could have predicted, could have said, well, the law is going to develop in this way, and therefore it's discoverable. That's not what he's saying. He's saying you've got to look at what the position was at the time, and look at realistically whether someone would have told you that your claim had legs, as my lord said, or had some credence. So then, sorry, I was reading 778. Secondly, thinking about the law evolves over time. Developments in judicial thinking in particular do not take place in a vacuum. Judgments are the culmination of the evolution of opinion with a wider legal community, to which practitioners, universities, legal journals and judiciary all contribute. So that's simply making the point that you don't just look at judicial decisions. You might look at contributions, articles by practitioners or legal journals, academics, etc. They all contribute because these are things that the court takes account of in coming to a judgment, if they're relevant, obviously. And you're very familiar with cases where you're being shown articles or foreign judgments, for instance, or things like that, as being relevant to your determination of a legal question. One would assume that the important thing is not the source of the article, but the cogency of the reasoning of the article. That's normally how it's dealt with. So they're just looking at that, and then they say it's not only judges who are influenced by the evolving body of opinion. Claimants and advisors respond to the same developments in their understanding of the state of the law and the decisions on whether or not worthwhile claims may exist. So they're simply saying the same criteria that would be relevant to a court. That's what claimants and their advisors would look at, because for the obvious reason that if you're advising someone as to how their claim will go, you want to take account of the things that the court will take account of in deciding the case. I mean, there's nothing, that's pretty obvious. So if you were an advisor at a time, you would look at you look at the case law, obviously, of the European Court in this context, but you would look at articles that have been written, books, etc., what people have said about the relevant claim. So all of that is not is very easy to understand. It's therefore possible to investigate how legal thinking on a particular question, for example, in the present case, whether the UK tax treatment of the dividends received by UK resident companies from non-resident subsidiaries was compatible with EU law, developed over time, and to ascertain by means of evidence the time by which a reasonably diligent person in the position of the claimant, such as in the present case a UK-based multinational company, could have known of a previous mistake of law, to the extent of knowing that there was a real possibility that such a mistake had been made and that a worthwhile claim could therefore be made on that basis.
That's the key phrase, isn't it? To the extent of knowing that there was a real possibility that a mistake had been made.
Yes.
In other words, the body of evidence that's described by Lord Reid in that particular passage has to be such that a hypothetical advisor that you go to would acknowledge that there was a real possibility that a mistake had been made.
Yes, exactly.
And Lord Reid expressly indicates that that's what he means by worthwhile.
Yes.
Yes. And that is presumably also what they mean when they come on later on, because they do state it in a slightly in terms of sufficient confidence to.
They put it in different. Yes, they
put it in different ways.
Numbered of different ways, but it's obviously all meant to be the same concept.
It is exactly, yes. Yeah.
But that particular word, worthwhile, he picks up several times later. But I think this is the first time.
Yes, well that was
used. He explains what he means by it.
Worthwhile.
I think that was a phrase used by Lord Brown.
It was
dissenting in DMG.
DMG.
Yeah. Whereas there's sufficient confidence to embark on the preliminaries comes from different line of case law. Yeah. I think Halford and Brooks and other cases.
Section 11 and Section 14A.
Yes. Yeah. Yeah.
Then importantly, the last sentence, the focus of attention should not be on judicial decisions, but on the claimant's ability to discover that he had a worthwhile claim. I mean, that does seem to focus on as I previously said, the reality of when the claimant had or could have discovered, had an ability to discover that he had a worthwhile claim.
Yes, but I would suggest that by saying it should not be judicial decisions, they're not meaning you don't look at what the law was at the time by looking at judicial decisions. What they're saying is that this is part of dealing with
It's part of saying you don't have to wait.
You don't have to wait till the end. You don't have to
till
wait
the
till
CJAU has told you the answer.
Exactly. Yeah.
Because you can discover you've got a worthwhile claim before then.
Yes.
An evolution of opinion is how he puts it.
Yes.
Which of course will be based in part on previous case law.
So you're saying he's using judicial decision. I mean, obviously you've got to look at judicial decisions because that's how you discover what the law is.
Exactly. Judicial decisions
You're
at the
just
time.
saying he's distinguishing it from you don't wait until you get the final judicial decision.
Exactly. Because this is part of the knocking down DMG, if you like.
Yes.
Which is, yeah. I was then going to, I was going to skip over, unless you may have read already, the part on consistency with treatment of fraud under section 32(1), and move on to paragraph 187. I'm simply, I could read a lot of this, or we could go through a lot of this, but I mean, I'm trying to pick out the key paragraphs. So, paragraph 187, consistently with other analogous provisions of the 1980 Act. Sorry, perhaps before I do that, if you just look at paragraph 186, that's a sort of summary, I think, of what he's been saying about fraud. And it's simply part of the argument as to why DMG is wrong, because in fraud cases you don't wait until.
Well, he seems to be treating Lord Brown's formulation as the same as being in a position to plead a statement of claim, doesn't he?
Yes, that's what they say. They're both being the same.
You've got a reasonable argument. There's a real possibility that a mistake's been made.
Yes. Or putting it another way,
I thought there's a distinction between being able to embark on the preliminaries to a writ and being able to plead fraud, because you can't plead fraud till you've got apparently credible evidence. And I think there's a decision of this court in Gemalto which says those tests produce different dates.
Exactly, yes. So the fraud on authority at the moment still is the statement of claim test.
It's the statement of claim test, but that's slightly different from where we end up with on this test,
yes.
the embark on the preliminaries.
This is an earlier stage, exactly. Because what we're looking at is whether you are, and there's very different ways of putting it, but whether you were on notice that there was a mistake. And therefore you can start carrying out all the investigations and getting advice. Including, the advice might include, how good precisely is your claim in relation to the amount you're going to have to spend, all the cost-benefit analysis. That's all the stuff that you do after this. The only question at this stage is, well, is there a mistake? Did you make a mistake, or is that just a hopeless argument that you couldn't raise? Because if it's the latter of those, then you don't go any further. If you're told it's hopeless, then that you haven't discovered it at that stage. It may subsequently become not hopeless, because cases may be decided unexpectedly or not anticipated later on, which would cause it to become not a hopeless argument, theoretically anyway. But at this stage, at the stage you're at, it wouldn't be discoverable. And indeed, if you had actually asked for advice at the time, and you were told, no, your case is hopeless, don't even think about it, then you wouldn't have discovered your mistake at that point.
Well,
because that must follow, otherwise it wouldn't.
I wonder about that. I think perhaps there's a danger of mixing up two concepts there. It's one thing to say, no, there's no real possibility that a mistake's been made. It's hopeless to argue that there's been a mistake in this case, because any argument... I mean, the problem is that in this particular context, the existence or non-existence of a mistake depends upon a reading of the law with an EU gloss.
Yeah.
And that, I think, is where there's that danger of a sort of mixing apples and pears. because you could say that there's a reasonable possibility that such a mistake has been made, but it's hopeless to argue it because we think that that argument's going to crash and burn if you raise it.
Well,
It is
maybe
semantic, but
if you are told, or you could have been discovered, could have been told that there is an arguable point, but the advisor may say it's arguable, but I think you're going to lose. You have discovered the mistake. What you then do about it is a matter for you, and you've got a 6-year limitation period to consider whether, despite the fact he said you're going to lose, he thinks, in his opinion, that you're going to actually press on, because it may depend on how much money is at stake, how much it was going to cost, etc., etc. These are all questions that are asked after this, but all we're looking at here is when does the
individual's litigation appetite can't determine when something is discoverable.
Absolutely not, and the Supreme Court made that clear. We won't come to that yet, but they make it clear that the particular characteristics of the individual claimant don't matter. What we're looking at is a well-advised multinational company, and that's the only characteristics that you're looking at. And the relevance of that is just what it would be reasonable for them to do, whether it would be reasonable for them to take advice. Because you might have a situation with an impecunious claimant where it would not be reasonable for that kind of person to take complicated expensive legal advice about whether they made a mistake or not. And I think the court recognises that you do look at the kind of person that you're dealing with in deciding what would be reasonable for them to do due diligence for that person. But we're not dealing with that situation. We're dealing here with multinational companies. But yes, you don't look at them and say a particular company has a particular foible that we don't like to litigate unless we know we're going to win or whatever. Therefore, we didn't bring claims. And no doubt there were all sorts of reasons why, because the different claimants in the GLO brought claims at very different times, starting from 2002 and going right on to 2009. So some didn't bring claims even after the European Court decision in 2006 for another 3 years. So you can see, and we don't know why, of course, that happened. We don't need to, but you can see that there will be different appetites for litigation in different groups of companies. That doesn't matter. But equally, I would say, because of the objective test, it doesn't matter. You don't attribute the advisor, if you're using the advisor tool, with any particular idiosyncrasies or foibles. The advisor has got to be someone who simply is in the place of the court, essentially, in determining, in giving the advice that would have been given at the time. So you don't assume that they're very cautious or they're very bullish or anything like that. So I was going to pick up page 180, paragraph 187, and I was going to pick it up just at the bottom of that page 790, just at letter H. As is explained below, the relevant fact that has to be discovered in that context is the fact that the claimant made a mistake, that being an essential ingredient of his cause of action. A claimant's ignorance of the legal consequences of the facts forming his cause of action is not something which section 32(1) is concerned, as Locke Walker made clear in Supreme Court 1. This is consistent with the intention of the Law Revision Committee, as was explained in paragraph 127 above, where they said it doesn't matter that you don't know that making a mistake gave you a cause of action. And then they say the sections 11 and 14 were considered by this court in the AB Administrative Defence, where proceedings were begun by the claimants at a time when they believed that their injuries had been caused by the exposure to radiation by the defendants, but had no objective basis for their belief. Their contention they did not then have knowledge of the facts forming the basis of the cause of action was rejected. The court held by a majority the knowledge did not mean knowing for certain and beyond possibility of contradiction, but that mere suspicion was not enough, and that in order to amount to knowledge, a belief must be held with sufficient confidence to justify embarking on the preliminaries for issuing proceedings, and it was therefore a legal impossibility for a claimant to lack knowledge for the purposes of Section 14.1 at a time after he issued his claim, which was, I think, what they were arguing in that case. And then paragraph 189, they're dealing with this question about whether you would assume when they brought claims that they had sufficient knowledge. Now, in AB, in fact, not only were they held to be out of time, but the Supreme Court, the majority of the Supreme Court, decided to strike out the claims on the grounds that they couldn't possibly succeed. They didn't have sufficient evidence, even at that point, to mount a claim. Essentially, what the claimants were saying in AB was, we ought to be allowed to continue with the claims, hoping that something will turn up, essentially, that will allow us to succeed. But the point that the Supreme Court made was that the limitation period had started several decades before, because they had become alerted to the fact that there was a possibility, at least, that their injuries were caused by the radiation. In 190, considering more precisely the point in time at which a claimant acquires knowledge for the purposes of Section 11.4 and 14.1, the majority of the court in AB Administrative Defence endorsed the test earlier approved by the House of Lords in relation to claims falling under Section 14A, which applies to actions for damages for negligence other than those involving personal injury. That was Howard and Fawcett. Lord Donaldson gave valuable guidance in Halford and Brooks. He noted that knowledge does not mean knowing for certain and beyond the possibility of contradiction. It means knowing with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the proposed defendant, taking advice and collecting evidence. Suspicion, particularly if it's vague and unsupported, will indeed not be enough, but reasonable belief will normally suffice. In other words, the claimant must know enough to be reasonable to begin investigate further. So it's not that you're in a position even to plead your case at this stage. It's an earlier stage from that. The formulation adopted in Halford and Brooks, Howard and Fawcett and AB Administrative Defence places the commencement of the limitation period slightly earlier than the fraud cases discussed earlier. The relevant time is when the claimant knows with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, rather than the point of time when he could plead a statement of claim. This is not the occasion in which to review the formulation used in the fraud cases, which reflects the special standard applicable to the pleading of fraud. The formulation used in Halford and Brooks is, however, consistent with the way in which the point was expressed by Lord Brown in Dutch-Morgan Grenfell and Lord Walker in FII Supreme Court 1. It's also consistent with principle. The limitation period normally begins to run on the date when the cause of action accrues. It is not postponed until the claimant has consulted a solicitor, carried out investigations, and is in a position to plead a statement of claim. For example, a pedestrian who is knocked down and injured by a car while using a zebra crossing has a cause of action against the driver, which accrues on the date of the accident. It will take time before he can issue a claim. He will need to consult solicitors, and counsel may have to be instructed to draft the claim. There may be many matters which have to be investigated, and that may take time. And it may be that his claim will fail in the end, if, for example, it's found that he suddenly ran into the path of the car, or the driver had a heart attack and lost control of the vehicle. Nevertheless, the limitation period begins to run on the date of the accident. It's not postponed until he's completed his investigations or until he knows that his claim is guaranteed to succeed. The purpose of the postponement affected by Section 52.1 is to ensure that the claimant is not disadvantaged so far as limitation is concerned by reason of being aware of the circumstances giving rise to his cause of action as a result of fraud, concealment or mistake. That purpose is achieved where the ingredients of the cause of action, including his having made a mistake, if time runs from the point when he knows, or could with reasonable diligence know, that he made such a mistake, with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the proposed defendant, taking advice and collecting evidence, or as Lord Brown put it in Deutschmark and Grenfell, he discovers, or could with reasonable diligence discover, his mistake in the sense of recognising that a worthwhile claim arises. We do not believe there is any difference of substance between these formulations, each of which is helpful and casts light on the other. So, the worthwhile, the difficulty is if you just latch onto one of these, like worthwhile claim or whatever, then you tend to sort of put in your mind what that means. And what they're saying here is that they both have the same meaning. What I would suggest is that what that means is a worthwhile claim means a claim that is worthwhile investigating. Essentially, if you look at these two, that's what it means.
But
because you know with sufficient confidence.
When you say worth investigating, does that mean the very first point in time at which you consult a lawyer? So you'd put worthwhile claim, if you formulate it the way you've just put it, the very first time you even make a decision to go and see a lawyer, that's it.
No,
no matter what the lawyer tells you, you're already, time's running. Is that right? That can't be.
No, because the first formulation is it has to be worthwhile to investigate, and in the context of a mistake of law like this, it would only be worthwhile to investigate if you knew or ought to. Sorry, if you could have known or did know that it was more than a hopeless or fanciful case.
Yeah, but you won't know that. Sorry, maybe I misheard you. I thought you effectively were saying that time starts running when you think it worthwhile going to get legal advice.
No, I said it's worthwhile investigating in the sense that has been described above. Because what was said above is with sufficient confidence to justify embarking the preliminaries to the issue, such as submitting a claim, taking advice and collecting evidence. So by investigating, sorry, I meant that. I meant
if you
those
put the two passages together, if you look at the passage at the end of 178 and you look at 193, you could have known of a previous mistake of law to the extent of knowing there's a real possibility that such a mistake had been made, and therefore that you can bring a worthwhile claim. And at that stage, your state of knowledge is such that you could justify embarking on the preliminaries.
Yes.
That's really,
and that's,
isn't it, reading the two together?
And then there's
In
another
other
way.
words, you know you've got an argument, enough of an argument to take matters further, putting it really simplistically.
Yes, and that's
enough
consistent.
of an argument that there was a mistake to justify taking it seriously and doing something about it.
Yes, and I think that's consistent with the other formulation, which we'll come on to see, which is it legally questionable? Is the basis on which you made the payment legally questionable? In other words, questionable in the sense not that you're going to succeed or indeed you've got a good claim or anything like that, but is it questionable?
I must admit that, speaking for myself, I think that the simplest formulation is the one at the bottom of page 787. There's a real possibility that a mistake had been made and therefore there's a worthwhile claim. Because
yes, well,
that sheds light on what's meant by a worthwhile claim, and then the other part of the formulation at 792 in paragraph 193 is that your state of knowledge is such that you would then embark upon making the claim in all the various ways that are suggested.
Yes, but presumably you'd only do that if there was a real rather than a fanciful possibility of claim, or it was legally questionable.
Yeah.
If it wasn't questionable, then you wouldn't be going.
You've got to be careful about not taking some of these little phrases out of context. Because if you just focus on the words taking advice, then you'd say, well, okay, as soon as you even think it's worth going and asking the question.
No.
Yes.
Now that can't be right, because you wouldn't know, I mean, you might have just heard a rumour and you ask your lawyer, but time doesn't start running then, presumably.
I would submit that what they're talking about here is, remember, the thing that we're talking about is discovering the mistake. That's one element.
Yeah.
But having discovered the mistake, you then have to take advice. What do I do with this mistake?
Okay, well, if you
that's the advice I would submit, what they're talking about. You go and take advice. Have I got a claim? How do I bring the claim?
Well, if by taking advice and collecting evidence, you're talking about the process that occurs after a lawyer has said to you, actually, there's something that's got legs here, but before we, you know, before you can issue a claim, you've got to actually collect some evidence together as to what you actually did in terms of what payments you made, you know.
Yes, you have to, well, there's that.
Because
but there's also a question as to, do I have a cause of action at all? I mean, I made a mistake, but so what?
Yeah, okay. As long as that's the way you're putting it, because there was it may have been I misheard, but I thought there was a flavour in what you said earlier, that almost at the first point in time at which you investigate by going to see a lawyer, that's it, clock's ticking. And I don't think that's really either sustainable or perhaps from what you just said, what you're really saying.
No, so in the context of mistakes of law, although I don't think the Supreme Court make this explicit, the first stage has to involve some kind of legal advice to discover whether you've got a,
Something that has legs.
whatever the test is, but whether you've got a viable
That you
claim.
might have made the mistake,
You might have made a
might have
mistake
made a payment under a
of
mistake.
law. In other contexts, of course, if it's a mistake of fact, you don't need to.
Real possibility.
Well, you don't need to have a lawyer, but you might be applying this test to, for instance, have you got enough evidence? Has evidence come which would justify you in taking advice? That would be a mistake of fact case I'm talking about, because of course the 221C applies to mistakes of fact as well as mistakes of law. So in that context, the first stage would not involve a lawyer necessarily. And indeed, road traffic accidents wouldn't involve a lawyer.
It depends what the fact is.
Yeah.
Yes, yeah. Well, it may. I agree, but in a straightforward fact case, when you made a mistake, and then some documents come to light showing that you made a mistake, or indicating, that you might have made a mistake, then that would be the stage. Presumably, when the limitation period would start, and then you'd have sufficient confidence to take advice, etc. Yes. But the rather odd thing about this kind of case is that it inevitably, I think, the first stage involves some kind of advice, notional or actual, as well as subsequent stages.
Well, really the first stage is you assume that the lay client, in this case a multinational conglomerate, will only know whether they've got a viable argument about a mistake if they seek legal advice or tax advice. So that hypothetically they go to see an advisor, and the advisor would say there is an argument here.
Yeah, that's
There's an argument here that you paid this money and you shouldn't have done.
yes.
Now, whether it's a good argument, a bad argument or not, but they've got to identify that there is an argument that at least has a runner. It's a runnable argument. If they would say to you, don't be silly, you couldn't possibly argue that you made a mistake about that, and that's a different matter. You don't get past the first part.
Yeah, if the notional advice would be, no,
I don't think you can seriously argue that you made a mistake.
there's this case which is against you. Look, you're not going to win. Then obviously that wouldn't be the case. Although we'll see that the Supreme Court do recognise the possibility that even in a case where there was, let's say, a House of Lords authority, that the discovery might occur before it was overruled. Because there may be circumstances in which you would be advised.
There may be a consensus, I suppose.
Yeah, you might be advised.
You've got that the House of Lords decision can't stand in the light of in the way that European law is developed, for example.
Yes, or, I mean, I think the example they give is Climate Benson, which overruled, not necessarily a House of Lords case, but certainly centuries of
A well-settled understanding of the law, which dated back to 17th century, which you can recover for a mistake of law, money paid under a mistake of law, and the House of Lords changed it in Climate Benson.
Yes.
Well, there must have been a stage before the actual judgment was handed down when at least some people thought there was a real possibility that the law might change.
Lord Gough. But yes, and there would have been academic articles, no doubt, I'm sure there were, written about it before, criticising the rule and saying this ought to be overruled, it should be overruled, it's not, etc. The question then would be, would depending on how much evidence there is of that, and how much cogency it has, would it be sufficient that it might start your limitation period running? Now, it's a bit of an odd thing to talk about because that is a mistake of law case in the first place. But in another circumstance where there was a long-term understanding of the law, maybe based on House of Lords cases, then certainly the Supreme Court do not rule out the possibility that you might discover it or be able to discover it before it is actually overruled. So even in that case, you wouldn't be able necessarily to wait for the limitation period to begin until the case is decided. And after all, I think as they point out, somebody will have challenged the case for it to be overruled. And so it's not completely fanciful.
That's precisely why Lord Sales and Lord Briggs point out how difficult this all is, because they point out, I think, in their dissenting judgment, that it's precisely in circumstances where there's been a change in the law that you're going to have this kind of debate. Because in most other cases, if there isn't a change in the law, then you can point to a legal advisor being able to say, you've made a mistake.
Yes. What's interesting, may not matter, but if you read the dissenting opinion, they only talk about two situations. One is where it's obvious ignorance, and the other is where there was a prior authority. They don't seem to recognise any other, but anyway, that's just shorthand. But that's what they talk about. And
it's certainly
focusing
food for thought.
Yes. Well, you can see that.
Recognise it's a dissenting judgment, but one can see where they're coming from.
Yes. So can we then? I think I'm on 201. Bottom of page 794. Hence, a situation which may seem paradoxical, but sometimes arises in practice, where in a trial on limitation, the defendant disputes the claimant's assertion that he could not have known or discovered a fact, which in relation to the merits of the claim, the defendant denies as a fact at all. There is in reality no paradox, because that's at the stage of an inquiry into limitation, the existence of the cause of action, and therefore the truth of the facts relied on by the claimant to establish it, is not the relevant issue. Put in general terms, the question is not whether the claimant could have established his cause of action more than 6 years, or whatever other period before he issued his claim, but whether he could have commenced proceedings more than 6 years before he issued his claim. The existence of the constituents of the cause of action, such as fraud or mistake, as verified the facts, is not an issue, is not the issue. And then it emerges from Lord Wilson and AB in the Ministry of Defence. And they say it's for that reason that, contrary to the views seemingly held by Lord Hope and Lord Walker in Deutschmark and Grenfell, the fact that the defendant disputes an element of the cause of action does not mean that the commencement of the limitation period is postponed until that dispute has been resolved. Now, of course, they're talking about what is very commonly the situation with limitation, where it's being dealt with at the beginning of the proceedings. Rather unusually in this case, we're dealing with it at the end of the proceedings. But if you were dealing with it at the beginning, if this had happened in 2003 after the writs had been issued and the particulars of claim, then you would be dealing with it on the basis that what they pleaded was correct, true.
Even though presumably you pleaded that they didn't have a claim at all.
Oh, yeah, of course, yeah. And that's the point that they're making here. That's not inconsistent, because when you're dealing with limitation, you assume that the position is as the claimants say, and you ask the question: Are they in time on the basis of their case? I mean, rather like all cases of strikeout and summary judgment or whatever. So the important thing in this case is not what happened in the end, what decisions were made by the court, European court and the court in the UK, but what was the mistake that was being pleaded by the claimants at the beginning. And I might come back to that after we look at this case, but in my submission it's a fairly straightforward, the pleadings are a pretty straightforward mistake of the kind that we were discussing earlier, simply that the provisions were contrary to European law for the simple reasons we discussed. So then reasonable diligence. That approach is also consistent with the well-established test for determining whether, for the purposes of section 32(1), the claimants could, with reasonable diligence, have discovered a fraud. Authoritative guidance on that topic was given by Mr. Lord Justice Millett, Paragon Finance. The question is not whether the plaintiffs should have discovered the fraud sooner, but whether they could, with reasonable diligence, have done so. The burden of proof is on them. They must establish that they could not have discovered the fraud without exceptional measures which they could not reasonably be expected to take. In this context, the length of the applicable period of limitation is irrelevant. In the course of argument, Lord Justice May observed that reasonable diligence must be measured against some standard, but that the 6-year limitation period did not provide the relevant standard. He suggested that the test was how a person carrying on a business of the relevant kind would act if he had adequate but not unlimited staff and resources and were motivated by a reasonable but not excessive sense of urgency. I respectfully agree. Lord Justice Newborough added in Sefton that it's inherent in section 32(1) that there must be an assumption that the claimant desires to discover whether or not there's been a fraud. Not making any such assumption would rob the effect of the word could, as emphasised by Lord Justice Millett, of much of its significance. Further, the concept of reasonable diligence carries with it the notion of a desire to know and indeed to investigate. The test explained in these dicta has nothing to do with judicial decisions establishing disputed trials after trial. It's concerned with the steps which a person in the position of the claimant could reasonably be expected to take before issuing a claim. And then they deal with the and they come back to that, but they do apply that approach. I think, apropos what I was discussing with Lord Justice Snowden, they apply that approach to this case. The pre-1939 equitable rule, can I move across to the passage at sideline 207? Where they say, I'm sorry, it says that is equally true. You have to know what was said. In a situation where one of the facts essential to the cause of action is that the claimant has made a mistake, whether a fact or of law, the fact that he has made a mistake needs to be discoverable in the relevant sense with reasonable diligence, but he need not know that he is consequently entitled to bring a claim. As the Law Revisions Committee stated, the mere fact that a plaintiff is ignorant of his rights is not a ground for the extension of time. That is why on the facts of Claimant Benson, the relevant matter which needed to be discoverable was that the swaps contracts were ultra vires, as had been established in Hazel, and not that a cause of action lay for payments made under a mistake of law, as was established in Claimant Benson itself. For the same reason, Mr. Justice Henderson was in error in the High Court 2 in favouring the view that it was only when the House of Lords gave judgment in Deutsche Morgan Grenfell that time began to run against the BAT claimants, since that was the first time an appellate court had held that a restitutionary claim lay for the recovery of tax on the ground that it had been paid under a mistake of law. The relevant fact was that the belief that the tax was payable had been mistaken, not that there was a right to restitution. So that was the point we discussed earlier. And then page 798, the practicality of the suggested approach. It remains to consider whether the test of discoverability suggested in paragraph 193 above, taken together with the standard of reasonable diligence discussed in 203, provides an approach to the application of section 32(1) to mistakes of law, which is likely to be reasonably practical and certain in its operation. To recap, as was explained, the suggested test of discoverability is that a mistake of law is discoverable when a claimant could with reasonable diligence know that he made a mistake, with sufficient confidence to justify embarking on the preliminary stage of a writ, such as submitting a claim, taking advice and collecting evidence, or as Lord Brown put it, could with reasonable diligence discover his mistake in the sense of recognising that a worthwhile claim arises. We do not believe there is any difference of substance between these formulations, each of which is helpful and casts light on the other. The standard of reasonable diligence is how a person carrying on the business of the relevant kind would act, on the assumption that he desired to know whether or not he made a mistake. If he had adequate but not unlimited staff and resources and was motivated by a reasonable but not excessive sense of urgency, the question is not whether the claimant should have discovered the mistake sooner, but whether he could with reasonable diligence have done so. The burden of proof is on the claimant. He must establish on the balance of probabilities that he could not have discovered the mistake without exceptional measures which he could not reasonably be expected to take. In practice, the application of that approach will depend on the circumstances of the case. For example, in cases where the claimant has made a payment on the basis of a mistaken understanding of the law which has resulted from ignorance, the mistake will normally have been discoverable immediately by seeking legal advice. Section 32(1) only has effect where a mistake could not have been discovered at the time of the payment with the exercise of reasonable diligence. On the other hand, where the payment was made in reliance on a precedent which was subsequently overruled, or an understanding of the law which was later altered by a judicial decision, the question will be whether the claim was brought within the prescribed period beginning on the date when it was discoverable, by the exercise of reasonable diligence, that the basis of the payment was legally questionable, so as to give rise to a worthwhile claim to restitution. So there we have a new legally questionable element. Depending on the circumstances, it may be difficult to identify a specific date, but doubtful cases can be resolved by bearing in mind that the burden of proof lies on the claimant to prove that his claim was brought within the prescribed limitation period. Clearly, where a payment was made in accordance with the law as it was then understood to be, the point in time at which the claimant could with reasonable diligence have discovered that the basis of the payment was legally questionable, so as to give rise to a worthwhile claim to restitution, will have to be established by evidence. The focus of that evidence is likely to be upon the development of legal understanding within the relevant category of claimants and their advisors, as explained in paragraph 178 above. So that was the paragraph that we looked at, where they were, I was submitting that what you were focusing on was items that would be influencing the court in making the decision. You remember 178 is quite important. Thus, in the circumstances of the present case, Lord Walker referred in FII Supreme Court 1 to there being a reasonable prospect that the limitation period could be deferred until the time when a well-advised multinational group based in the UK would have good grounds for supposing that it had a valid claim to recover ACT levied contrary to EU law. This point is considered in greater detail in para 255 below. Evidence in relation to matters of this kind may well include expert evidence concerning the state of understanding of the law within the relevant categories of professional advisors during the relevant period. It is true that this approach involves a more nuanced inquiry than a mechanical test based on the date on which an authoritative appellate judgment determined the issue is an issue, but it would be unduly pessimistic to conclude at this stage, some rather ominous words, that it would prove to be unworkable in practice or too uncertain in its operation to be accepted. Can I just go back to paragraph 210 then? There are three circumstances outlined there. One is where it was ignorance, which I take it to mean you could have found out the answer by just opening a book, pretty much. Anyone, you clearly just made a clear mistake due to ignorance of the law. That's what I understand that to mean.
It's just somebody who doesn't bother, just makes a payment without bothering to ask a lawyer.
Yes, doesn't ask a lawyer or thinks he knows the answer, but in fact doesn't. Yeah. On the other hand, where the payment was made in reliance on a precedent that was subsequently overruled, so that's a precedent situation which was overruled. And then the third of these where is where an understanding of the law was later altered by a judicial decision. So what that's looking at in my submission is where, although there wasn't a decision on the point, the law was well understood to mean X. And it then turns out that a subsequent decision says, no, it wasn't X. Everybody was wrong about that. In fact, it's Y. And there are cases, of course, where there aren't. Sorry,
Klein-Walt-Benson is a paradigm example, isn't it?
Yes, although there were judicial decisions, although not at the level of the House of Lords, I think, on that. But yes, you could say that. There was a Spectrum case, although there was a judicial decision, but that was, everyone then assumed that was the law in relation to something to do with floating charges or something, I think. It was then overruled subsequently by the House of Lords, I think, who said the understanding everyone had for many years was wrong. And you could imagine a case like that where there hadn't actually been a first instance decision, but just everybody assumed that to be, everybody thought that was the law. You might have had writings by eminent company lawyers. I'm not sure who the names of them would be, but they might have said this kind of thing is a floating or a fixed charge or whatever. And everyone followed that, and for years and years, and then it was overlooked.
Yeah, I mean, there are plenty of them kicking around. There's a decision, I think, that is currently with the Supreme Court on, for example, the question of whether limitation applies to claims under Section 994.
Yes.
And everybody just assumed that I was as guilty as the next. That it didn't. And so held by the Court of Appeal, and then suddenly, somebody raises the argument, and we look at it more closely, and actually, maybe there is one.
Yes, exactly.
I think we're still waiting to hear whether that's right or wrong.
Yes.
Yeah, so, yeah.
And I suppose that reveals to you the difficulty of relying on assumptions as to what the law is. And there's another example, I think, Section 53(1)(c), which it wasn't actually overruled, but I think Lord Briggs said this argument that it only applies to land could have been raised in 1926, but it's too late now because there's been 100 years of assumption in the case law that it applies to personality. I think that's the case.
It sometimes happens also where Parliament passes a statute and everybody just operates on the basis of an assumption as to the way it's supposed to work.
Yes.
And at some point, some strange factual circumstance arises and it calls you to question it. And when you actually look closely, that isn't what it means at all.
Yes. And one of the questions in this case is whether, when you're applying whatever the test is, whether you're using a notional advisor or the court, the question is, what do you do in a situation where everyone may have made an assumption, but in fact if you sit down and look at it, then you would come to a different conclusion. That's one of the issues, because the judge rather says, well, you wouldn't do that in this case. You would simply deal with it at a higher level, I think he talks about it.
Can you just refresh my memory from earlier this morning? The situation we're looking at here, did I recall correctly that you said that actually one of the taxation structures that we're looking at had been in existence pre-1973?
D5.
Schedule D, the taxation of foreign dividends and UK dividends.
So until the UK joined the EU, there would have been no basis for anybody to think that there was anything wrong with that.
Yes, I mean it's a bit more complicated because we had a partial system, and then we had a classical system, and then before then. But yeah,
the argument,
right in principle, nobody would be thinking because there's no reason to consider it, obviously.
At some stage, Mr. Stewart, not necessarily now, I would benefit, I mean, you all understand these terms, but the classical system and imputation system and so on, they're not immediately obvious to those who don't practice in the field.
Yes, perhaps I will cover that, yes. The problem with this case is there are so many things that you can cover. That's not criticism. But I will, yes, because I think you find references to that in the evidence, and indeed in the argument that, for instance, it said that Verkuyen was a classical system rather than an imputation system.
Yes.
Yeah.
Richard's judgment.
Yeah, maybe it's explained by the judge.
It is.
Yeah. But anyway, I will cover that. Can I try then if I can finish Supreme Court 2 before lunch, that might be. So I wasn't going to take you through the summary, which is really just repeating all the things that we've already had, which is paragraph 213. I mean, it is obviously useful if rather than reading all the rest of it, you can read the summary, which I think gives you everything. But can I then take you on to 229 first? because there's a discussion of this kind of case. Secondly, and this is in response to the argument that this is going to cause difficulties, this approach. I think it's in response to essentially to the dissenting opinion. The uncertainty which is liable to result from the application of 32(1)(c to mistakes of law should not be exaggerated. In most cases where a mistake of law is made, the application of section 32(1)(c will not produce disruptive consequences. That is because the mistake will normally have been discoverable at the time of the transaction in question by the exercise of reasonable diligence by obtaining legal advice. The commencement of the limitation period will not therefore be postponed. Cases where advice as to the correct state of the law was not reasonably available at the time of the transaction, and where a right to restitution might in principle be available, are likely to be unusual. One example is the class of cases where the mistake of law is the retrospective result of a judicial decision which upsets an established rule of law on the basis of which payments have been made, what Lord Hoffman described as a deemed mistake. Cases of that kind should, however, be highly unusual, as courts do not often overturn established rules of law, and in considering whether to do so, they attach particular importance to the security of settled transactions. The present proceedings and the other proceedings mentioned in paragraph 5 and 6 above are not, however, concerned with deemed mistakes, but with actual mistakes arising from a unique set of circumstances. The UK's entry into the EU with supranational laws, which had to be given priority over domestic statutes, resulting in the gradual application of the EU principles of freedom of establishment and freedom of capital in the field of taxation, and the eventual realisation that UK tax legislation might be incompatible with those principles. Such circumstances are of a wholly exceptional nature. Well, let's hope so. And
they may
finally,
be exceptional, it doesn't make it any less difficult to apply them.
No, it doesn't. And of course, in reality, it's these kind of exceptional cases that the law is developed very generally, like this one. And then finally, I'm going to take you to 254 because so the rest of the judgment in between is all about whether to overrule Climate Benson, which they decide not to, and then whether to overrule Deutsche Morgan Grenfell, which they decide to do. And then paragraph 254 is really applying it to this case. This appeal is brought against the decision of the Court of Appeal, and this judgment is concerned with the appeal only insofar as it relates to issue 28 limitation. As was explained, the decision of the Court of Appeal on issue 28 was based on the application of the approach established in Deutsche Morgan Grenfell. For the reasons we have explained, that approach cannot be upheld and the appeal on issue 28 must be allowed. When this court cannot, however, determine in the abstract the point in time when the test claimants could, with reasonable diligence, have discovered to the standard of knowing that they had a worthwhile claim, that they had paid tax under a mistaken understanding that they were liable to do so. That depends on an examination of the evidence. As we've explained, EU law in relation to tax regimes which discriminated between companies based on one member state and companies based on another developed through a series of judgments in the Court of Justice, including Verkuyen, Lentz and Mannanen, discussed in paragraphs 24 and 33 or 34 above, Hirsch. Each of these judgments was itself the result of a claim made years earlier. In Hirsch, for example, the claim was filed in 1995, 11 years before the judgment of the Court of Justice. DMG was aware of the claim almost immediately, and it was for that reason that in Deutsche Morgan Grenfell, Lord Brown considered that time began to run for DMG in July 1995. But the date when the claimant became aware of another claim and appreciated its potential implications for its own situation is not conclusive. If a claimant acting with reasonable diligence could have discovered that it had a worthwhile claim at an earlier time. Equally, the answer to the question arising under section 32(1) does not depend upon the characteristics of the particular claimant, whether, for example, it was inclined to await further developments to allow the taxpayers to make the running. The standard is could, Lord Justice Millett emphasised in Paragon Finance, and the test is objective, as Lord Justice Millett explained in the same passage of his judgment, and as Lord Walker made clear in FII Supreme Court 1, when he referred to the time when a well-advised multinational group based in the UK would have had good grounds for supposing that they had a valid claim to recover ACT levied contrary to EU law.
I mean, they're assimilating the concept of objectivity with a notional, well-advised multinational group, rather than just simply saying you take actual evidence from any actual person as to what they subjectively thought at the time.
Exactly, yes.
So, but it's objective in that sense.
Yeah, exactly. That's my submission, and that makes the test workable.
But you still have to build into it, quotes, a well-advised. So, I mean, the point is you still have to have some, as it's absolutely transparent, you've got to have some evidence as to what advice would have been.
Oh, well, and that evidence, rather oddly, would include, and perhaps mainly include, things like decisions of the European Court, which have been taken before then.
Yeah, but it's
Because they would clearly be relevant evidence in a sense
question-
to what would be advised.
Okay. The question is, but it's still, it is a well. You have to look to see, as a matter of reality, what a well-advised or
Yes.
notional multinational group based in the UK would have been told.
Exactly. With the emphasis on well advised.
Yes. But not, yeah. But implicit within that is from somebody at the time.
In relation to this particular point about, in this case, about the compatibility of the provisions with EU law, because that's the mistake. That's where the mistake arises. So that's what they'd be advised on. Just to make, I'm sure that's what you.
Yeah.
Yeah. Not
They have
on
to
whether,
have been advised.
not about,
there is
not
a,
about whether
there
they
is
can
a
make
viable
claims.
argument that that the domestic legislation is incompatible with European law, such as to give rise to a claim that you've paid this money wrongly.
Well, such to give rise to a yes, exactly. If now whether that is a claim you can bring and whether you will succeed is not the question. Because there may be all sorts of reasons why you can't
Yeah.
bring a claim, but
There was,
that's not.
there was one other point you said that they made, which you haven't taken us to, I think, which was that in a case where a case is being overruled, but a decision is actually later overruled,
Yes.
time doesn't start when it's overruled, it can start earlier, you said.
Yes, I think that was a passage I did. Sorry, I thought that
I
was.
thought it was a passage to you.
Well, maybe you did, in
Yes.
which case I'm sorry.
Yeah. I mean,
the one that you took us to a few minutes ago, which drew the distinction between I can't remember the label that was attached now. Lord Hoffman, a deemed mistake and a non-deemed mistake, isn't it? The passage at 229.
229.
yes. Yeah. Well, I think there was
I wonder if
210. Yes, I think that's right. It's 210. Yes. Sorry, that's the.
yeah.
Yeah.
Yes, if you look at 210 just below letter C,
Yes.
where the payment was made in reliance on precedent or something overruled or understanding the law later altered, the question would be whether the claim was brought within the prescribed period beginning the day when it was discoverable by the exercise of reasonable diligence.
That the basis of the payment was legally questionable.
Yeah. So it's not when it's overruled. It's the point at which it was legal.
There's also a passage, I think, at 240, which is 240 on the
Oh,
side.
right, yes. Yes. Oh, yes, you're right, Malone.
It's the last line of that paragraph. It does not follow from the fact that the House of Lords reached
Yeah.
its decision in 1997. A hypothetical claimant could not have discovered his mistake before that.
No.
And a hypothetical claimant in that case would have gone to a lawyer and said, well, I've made this payment under a mistake of law. The swaps payments, can I get it back? And the well-advised lawyer would say, well, there's Court of Appeal authority, it's dead against it. But you might be able to get the House of Lords to take a different view. And that is apparently enough.
That could be enough. That would be enough. Yes. That would be enough. And what they're pointing out that if you went to a lawyer in 1996, 1995, depending on what was being said about the mistake of law rule exclusion, you may well get that advice at that point. So your limitation period would begin before the overruling actually took place.
It's quite tough. I mean, you've got a claim which is only going to succeed in the Supreme Court. It's not going to succeed at any other level of the judicial system. You say time begins to run, even though the entirely accurate advice is you'll lose it in the tribunal, you lose it first instance, you lose it in the Court of Appeal. It's only if you can get the Supreme Court to give permission and get the right people on the court.
Well,
You've got the Supreme
sure those are
Court
factors
against you, let's go to the European Court.
taken into account. Well, there are
I
different.
think most people would say, let's go down the pub instead.
Yeah.
And that's quite a that's quite a long
That's a decision
shot.
that you might well make. But that's the same, and if you have a road traffic accident and somebody runs into you, you might decide, I'm not going to bother suing them, I'm going to go in the pub instead.
Oh, it's not quite fair.
That doesn't stop the limitation period running. And
I'm not quite sure with that. I have to say I don't find that being knocked over by a car a particularly helpful analogy.
But the point that the Supreme Court were making throughout this is that in other contexts, it is a very tough rule.
Yes,
And
there's
the
got to
way-
be a bright line.
Yeah.
The way that it was applied in AB, for instance, and in other cases, is very tough in other contexts.
AB is a very controversial decision,
Yeah, but it is.
and legal commentators are still carping about it to this day.
Yes. But, well, if someone wants to take a case to the Supreme Court, overrule it, then good luck to them. But anyway, in this, it's not just AB, there are other cases that are mentioned here. And indeed, there's an article in the very back, we put in the very back of the authorities bundle by Samuel Beswick, who in fact wrote an article prior to Supreme Court 2 that they mentioned in the judgment. I don't know if you noticed that, promoting this approach. He wrote an article after Supreme Court 2 where he reviewed some other cases in other contexts and showed that they were pretty tough, the way that it comes out. But it is. You do have to remember we are only talking about the beginning of the limitation period. We're not talking about when you have to bring your claims or anything like that. So it's not. I mean, the limitation periods are tough in some ways to claimants, but there are good reasons for them. I think, as the Supreme Court set out in this case, there are good policy reasons for limitation rules. So there's no reason why multinational companies making mistakes of law about tax should be in a better position. Than anyone else.
Before we rise for the shorter adjournment, Mr. Hewitt, would it be possible for somebody to tell us what these two clips that have been put on the bench, where they're supposed to go? You can tell us after lunch where we should put them in, because I'm always worried about loose papers getting lost.
Have you got a bundle called HMRC additional document?
Yep.
I would put them in there.
They both go in there.
Are they?
One is page 197 to 199,
Yep.
and one is 200, but they don't seem to follow on from one another.
Oh, they do.
Mine don't.
Oh, they're different things though.
They're different things.
Yep.
If you actually read page 199, it does not follow on to page
You should have
200.
have you got that as well?
No.
So that's the index that tells you what they are.
Oh, is it? Right. Well, I don't have the index,
All right. Well,
which is why I asked the question.
we'll make sure you
Thank you.
get it.
Right, I'm going to put 197 in. And perhaps somebody could be kind enough to send me the index. That would be great. Thank you. 2:05. Thank you.